All right, folks.
Absolutely.
I want to thank you all for joining us today, and welcome back to the Research Colloquium after a well-needed research and winter break. It is my pleasure to welcome Jeff Staton here today with us. He is a paleo speaker, and I think the last of our paleo series since we front-loaded in the fall. Jeff is a professor of political science at Emory, as well as the director of the Center for the Study of Law and Politics. He serves as the Judiciary Project Manager for the Varieties of Democracy Project, or VDEM, for those of you who are familiar with it, and his research broadly covers the fields of comparative politics, law, and society. He has done work on judicial power, judicial performance, judicial independence, and the work that he's going to present for us today is firmly within this research focus. So Jeff is going to be presenting work from his forthcoming book on the ability of the judiciary to maintain and bolster democracy, kind of broadly defined, and he's going to talk about some of the ins and outs of that. As usual, as per our format, Jeff's going to take about 5 minutes to take us off, contextualize the work that we read, and then I'll be keeping the cue, so feel free to gesticulate wildly, and I will write your name down. So without further ado, Jeff, tell us what you're going to talk about today.
Sure, thank you so much. This is going to ring at 5 minutes because I'm told I'm supposed to stop talking. So thanks a lot for this opportunity. We suggested that I send something that was work in progress. Very much so, this is work in progress. So I'm looking forward to your comments. What I sent was like a summary, I guess, of the book manuscript, and I'm happy to talk about where we're going with individual components and kind of try to clarify things that were unclear. I'm also just really interested in hearing some thoughts that you might have. I think for us, one of the central empirical challenges will be that the most interesting propositions have to do with non-barking dogs, so behaviors that just aren't observed. And so we have a number of things that we're doing. I can talk about some of those if you like, but as we were talking about this morning, we're really thinking about how to really think about or do work. This would be outside of my work. This would be historical work, like really looking in archives to think about how cabinets were considering possible policies that they didn't take. So that's sort of things I'm really interested in learning about, if you have thoughts. So what does the book do? The motivating question comes out of both popular culture statements, but also rule of law advocacy statements, which seem to suggest that courts of a particular type might be important defenders of democratic regimes. And taking that claim and putting it into a conversation with all of the political science and political economy research, which reminds us that judges are attacked verbally, they are imprisoned in some cases, they are politically appointed, their budgets are cut, and for all these reasons we have a sense that they behave in ways that makes them careful. So if that's all true, how could they possibly be defenders of democracy? That's sort of the motivating question. What we do in the book then is a couple steps. The first is conceptual. So it's about defining what we mean by democracy, okay? Which is to say this particular stream of comments about what courts could do is bound up in deep questions about what they mean by what is democratic. We take a more procedural approach to that, but I'm happy to talk about what it might look like, or the argument might look like, to get a more substantive view of democracy. The second thing we do is take a number of arguments that have been made about courts' roles in democratic states and bring to bear new data on about 115 years of experiences globally to think about whether we've got evidence that are in support of these empirical predictions that come out of what the literature would suggest. What we find is as you see some of it in the paper, just a mixed record. There are things that make sense, and there are things that really don't. In particular, we'd highlight just the massive amount of non-compliance that we observe with courts in countries where you think their courts would be respected as a routine matter. So that's that part of the book, sort of reviewing what other people have said. Then we build an argument which is really the heart of the book, which has to do with trying to understand what it would mean for judicial review to help leaders solve what people in this regimes literature think is a very serious problem for democratic states. That is, because of informational asymmetries, there will be powerful people taking actions that may or may not be consistent with our understanding of what the regime would allow. And that was a fundamental problem of like communicating that what you're doing is something that an opposition party leader, were she to have the same information you have, would actually be, would take the same action that you're taking. So there's a series of claims that courts can help resolve that informational challenge. And what we want to think about is how they would do that. And the last little piece, conceptual, is like, it's supposed to be courts that are so-called independent. And so one of the things we think about is like, what exact independence from whom? And how does the kind of idea you have about independence affect their ability to solve this informational problem? The end of it, I won't let it ring, it's been about 15 seconds. The end of the last part of the book is really taking the primary argument, which is what courts are doing, if anything, is helping incentivize prudence on the part of current leaders and opposition party members. And so the last part of the book is thinking through how would you observe prudence, right? And how would you evaluate an argument like that using the kinds of data that we can observe? So I gave maybe a quick example of our intention to think about choices to declare emergencies. That's one sort of context. But as I said, we're really interested in doing some more historical research, at least in a couple cases, to think about how cabinets actually debate taking actions that could look like they were aggrandizing power, when in fact they were not. So that's sort of the project.
Great. All right, who'd like to start us off? Go for it, Lee.
I can. So, Jeff and I were talking before this, but one thing we didn't get too much is how do you model accountability, and accountable to whom? I mean, if we want judges to be so. Also, a lot of this is read through the eyes of a Supreme Court, but we also have federal and state justices who may play as important of a role, and sometimes they're elected, and sometimes they're appointed. And we know that their behavior is very different, not very different, but different, measurably different if they're elected versus if they're appointed. But you don't really talk about accountability, and it interacts with independence, because, or could you speak a little bit about how you guys are thinking about accountability?
What's the
You can either collect questions or respond. It's entirely up to you.
Sure. Well, I'll get. It really is up to me.
It's really
Okay.
Really?
Awesome.
Not the next hour.
Yeah. No. It's okay. Right. So there's two things in there. One is how do we think about accountability. The other is there are these. The story here is sort of told through the perspective of a peak court, a Supreme Court, a constitutional court, whatever. One, rather than maybe through a system. And so maybe take up both things in order. The other issue is about accountability. So the accountability question, I guess what I'm wondering is sort of, that's tied to what do we think are the preferences of judges, and who are they responding to? Is that
Yes.
kind of what you're thinking?
Yes. Who are they accountable to?
Mm-hmm.
Right.
The
So
Constitution, as they interpret it, the citizens of that state,
yeah,
or
the judges that we have in mind are accountable to directly. They're accountable to legislators, and it's depending on the system, like whoever has formal authority to change their institutional structure, their salaries, people who have control over their posts.
right?
Primarily, that's what we're thinking about. One of the things that was important to us in thinking about the motivations for judges in this kind of context is to get away from what I think a lot of the literature, at least in political science, does. The political economy literature, as it manifests in political science with respect to judges, it's a small one, but they sort of take a kind of view of judges as sort of single-minded
Right.
seekers of compliance.
Yeah.
Right? They're at all times trying to make sure that they're not defied. And I just, for reasons associated with this project and other things, just don't think that's quite right. And so I think there's a piece of what we're doing here, which just asks, do judges just want to get legal questions right the way they understand it? We talked a little bit earlier, it could be that there are peers out there that are evaluating them. That would be, that would be one way of thinking about what might motivate a judge to get the legal question right. There are too many courts that are defied too often that continue to issue decisions that are challenging of state power for me to believe that they are all seekers of compliance. So that's kind of the first setup. Looking at it from this, I mean, we talked a little bit about this. Like the thing that I'm kind of wrestling with, Chris Renock, my co-author, we've been kicking around this other idea, which is we have been thinking about the way that a peak court might influence information revelation between competing political parties, but we haven't really, and if you think about the story we motivated with, that story is about the lower federal courts in the United States. Right? It's about judges across the country issuing injunctions for the whole country. And so one of the things we've been thinking about is the way that a judicial hierarchy creates opportunities for the public, for leaders to learn what people are thinking about generally. Like the fact that people showed up at these airports and were protesting was important information. And you get like a pause pushed on the policy by the lower courts, right? Which maybe allows time to reconsider what's been happening. And so that struck me as maybe another piece of the story that we haven't been thinking about, right? Which allows you to think about, would you want to organize your judicial system with a peak court, or do you want jurisdiction to be diffused to allow for this sort of like rapid sort of pause pushing function that allows information to emerge. So that's sort of another kind of idea that we've been kicking around. I don't know what to do with it quite yet, but that's kind of what I'm thinking.
I really enjoyed reading this because it really brings law more towards the forefront of a lot of the research questions. Well, at least it brings law to the forefront when sometimes it's just used as a control variable in a lot of regressions of many different research topics. And the several times where you identify, when you do the deep dive into the empirics and you realize that maybe theory doesn't hold up as well as we maybe thought, is this maybe a cautionary tale to other scholars who aren't studying law directly but are using it as an important control? So like, I don't know, a world governance indicator for rule of law just kind of as a control. Do you think maybe other social scientists are playing a little too fast and loose with the importance of law, and maybe we're not conceptualizing it as enough as we need to?
Almost certainly, yes. I mean, I guess, so the way that this project started, it came from two positions, so you can even see it in the way we're setting up in the summary. There's an entire branch, as you would know, in political economy that would suggest that not only should these things really not be even controlling for some potential conflict, there's just none to be. They're not relevant, these courts, right? Because the courts are products of the political system. The independence of these courts are a product of, effectively, how competitive the party system is. They're an outcome, and as a consequence, they don't do anything. So that's like one entire approach is based on that. What we want to do is think about, so that's one. The other was the world I came out of, which was trying to think about what are the conditions under which judges would behave as checks on powerful executives. And those all have conditions that have to be met, and some of them are in the party system, so how fragmented is your government, for example. And if it's just that, then these things are just outcomes. So setting aside, have you conceptualized the thing you're doing in a clear way and using measures that are valid measures of this concept you have. There's just like an entire piece of the literature, I think, which suggests these courts effectively they're basically outcomes. They're not going to do anything. So that was actually the first thing. With what happened when we started looking at the data was going, wait a second, if it were the case that they were just products of a competitive party system, then these types of pieces of information we wouldn't observe. Right? The question you're asking is well beyond what I've just said. I mean, it's an important important point. I think one of the nice things about what's happened with varieties of democracy is you're getting the ability to actually, or at least even if the measures aren't right, it's giving you a sense of like, here are the things you actually would want to measure below the level of, does the state have, quote, rule of law, this multidimensional concept that has been scaled with, 75 things by the World Bank.
Right.
Yeah. So,
I have one question about the communication part and maybe the more theoretical thing is why the elites cannot use other mechanisms to communicate or to solve this communication problem? Why it must be through the judiciary, essentially? Why they cannot use parliament or just a bargaining table to solve this communication problem? And essentially, why we think is the best way to do it through the independent judges, essentially?
yeah, no, that's a good question. I don't think it's necessarily the best way. I think it's a way.
Okay.
So I'll put over here in this imaginary conceptual bucket other ways. So other kinds of things that could do it. I could imagine contexts where religious leaders serve this function. Possibly certain kinds of intellectuals, maybe the press, maybe, right? The thing that we're talking about is a function where you're giving them an opportunity to send a costly signal. And what's going on in a parliament and in deliberation is that if you could figure out a way inside that deliberative framework to allow them some way of signaling with cost, then sure, that could work. But that's sort of what we're imagining. The thing that's driving it is the fact that the thing that's driving the information, insofar as there's revelation, is the willingness of the state to basically tell a court that it's not going to comply. That's the thing that's driving it. So if you have something like that, a public action you could take that's costly, I think it would more or less do the thing we're imagining.
Okay, so it's one elite sending the signal to the other.
Yeah.
I am willing to comply or not, essentially.
Right. I mean, so Karuba and Gobble have this book they published a couple years ago, and it's about the European Court and the way that the Court of Justice of the European Union facilitates costly signaling amongst member states. And their idea is that they're doing it. So the concern is there's a state that's not in compliance with EU regulations, and the answer is we're not doing it because there's a particular emergency in our state, or the conditions are not right for us to comply if you were in our position. So it's more or less the problem you've got. You wouldn't comply either. And so that's the kind of thing that gets litigated. Right? And so what they imagine is the litigation process, briefs get filed. And it's the way that the distribution of the briefs set up a scenario for states that want to be let out of European regulations are able to what they call somehow like, it's basically burning money. But it's never clear to me like how you do that in a legal brief, right? Like the writing of the brief itself would have to be costly, which doesn't seem particularly costly to me. I mean, right? So, and it would also create a whole bunch of really nasty theoretical thicket, right? Because if it was the case that they were signaling through their briefs, what they imagine is, there's a possibility that a government would be able to write a brief that was not truthful in order to get another party to spend money on them, right? So it's just not. I think it's possible, but that's sort of the idea they have. It's through the briefing process, and we just think of something a little bit more simple, like no, just literally not doing what they said. That's the thing that generates. It doesn't in all places generate costs, right? But when it in places where it would, that's where they could influence information.
Could I just follow up on that? So, I mean, that's a good case where there could well be an informational asymmetry. And that's the way you generally model one role of the court as a bulwark of democracy. And I can see that in the EU context where they don't know the domestic conditions in Slovakia or someplace. And if they were in Slovakia, they'd see why they're not complying. But in other instances, it seems to me that it's an asymmetry of preferences.
Yeah.
between the executive and the legislative. And they're just a third player in a sort of, simple spatial model. They're a veto player. You can comply or not with the court's decision, but nevertheless, there's some then you do discuss the role of public opinion, and so I think that needs to be brought more to the forefront. So the court is acting as a veto player between the executive and the legislative branches who have different preferences, and they're pulling it to a different direction, which may or may not comport with public opinion. But public opinion is also out there enmeshed in this, and I think a spatial model might help solve this and see under what conditions it's an informational problem, and under what conditions it's differences in preferences.
Yeah.
And right now those are conflated in the way I was reading it in here. Some of the examples you used, like the immigration issue or
Yeah, I mean, the way the model's set up, it is absolutely, there's an informational asymmetry.
Right. Yeah.
And it's not just about, something that, no matter what information I would have, I could possibly get that you think you have that's private, I'm going to disagree with you.
Right.
No, I mean, that just is basically, for us, kind of a primitive feature of the argument. It's like the way that we're entering the conversation with people who are thinking about what makes regime survival so challenging, that it is this informational asymmetry and managing it. That's the thing that has to be solved. So that's why, I mean, we took that approach. We've got, there's a feature of these old separation of powers models that are in this model, which is the court's got to be incentivized to actually take actions that put itself as a potential veto.
Right.
But we haven't been thinking about it. What would be the? I mean, what would a court be doing in a world where there's no informational asymmetry?
Right.
We just disagree about some policy, and we throw in a third party. How would that? I'm just trying to think through. I can't. What would be the service provided by this third party with respect to our continued commitment to changing power via elections?
Well, because they have different, let's say, time horizons.
Okay.
That's for sure, with most Supreme Courts. And to the extent that their audience is either the reputation amongst their peers, and to some extent public opinion. Just think of it in a simple spatial model. They necessarily will raise the cost to both these other parties for taking certain actions. And so I think that's a way. It doesn't say that your informational story is not accurate. It's saying
it's an alternative.
Well, I think they're complementary. But in a lot of cases that I know, the court is simply saying, this is not our view of the Constitution, and we're holding to this because we have a longer time horizon. You think this is an emergency, we don't.
Yeah.
I was talking about the municipal moratorium case.
Okay, so Anthony Romero, this is ACLU director. I mean, I do think this is maybe what he has in mind, right? So this is you need a substantive view of democracy to make it,
Right.
to my mind, to make it work. That is, there are some limits on the kinds of policies that we can validly enact in this system. And what's going on with child separation or the travel ban is somebody's taken the policy so far outside, and all that's happening is the court's just, in principle, moving them back into the center.
Yeah.
So, that's what you're saying, right? Yeah. that is absolutely, and you
That's
still
what these
have to have the
federal
court
judges-
incentivized to do that.
Yeah.
And in many places and in many time periods they won't be, and that's another thing we talk in the book is like,
Right.
often they won't. That seems like obvious, I think, to all of us. We can name a whole bunch of cases in which they got run over. But yeah, that's an alternative. That's right. We haven't taken that route, but I guess so what I want to think about is what does that say about the empirical patterns we're observing? Now, if you just took that approach, and so what you want is conditions under which a court, say, backed by broad beliefs among the public that judicial review is appropriate and they ought to be obeyed. If a court like that can hold competing parties potentially in a polarizing world to something that's more centrally focused, what would that model say about whether we should observe their decisions obeyed? For example,
or the dog in the night.
Yeah.
And then I'll be quiet. There's an article by Spiller and Jelly about Supreme Court and Roosevelt's court packing decision that takes the spatial modeling approach, and it's really about preferences.
Sure.
And Roosevelt's preferences being way out here.
Yeah.
And so on. So and the legislature being somewhere in between, and the role of the court.
Yeah, I mean, I think it sounds about right to me in the sense of it's an alternative thing that they would do, as long as they were incentivized to do it.
Yeah, and I think you need to work more on the objective function of justices.
Yeah.
I just had a question about your decision to look at states of exceptional rule as the way to model the game. Seems to me like a separation of powers question more than I understand representation is a component of democracy, but I was curious about changes to electoral institutions, financing of parties or districting decisions, how transparent they are, those sort of political questions that courts often avoid but sometimes step in and I think we're talking about like the function of courts, what they would be if there weren't informational asymmetries. There's the Israeli Supreme Court interpreted the equality provision not to mean one man, one vote, but also that financing had to be equal for all political parties. You couldn't just fund the ones that performed well in the prior election. So, I mean, I understand it fits the information asymmetry model, but I was just curious what else incentivized that, and then I just have a follow-up question.
Why did we go down that route empirically? So the basic idea is to look at two things. One, for those states that face significant threats and natural disasters, right? Like, how does the choice to declare an emergency, like what's the relationship with that choice and what your court system looks like? But also, I think probably the best test is setting aside our ability to really get this thing identified. Well, just set that aside. But like, there's a test that has to do with looking at how do states respond to national emergencies in the presence or not of court systems that are empowered to review their choices, right, and are capable of or willing to make a decision that is contrary to what the government says. So that was the idea. The reason was we're looking for behaviors where there would be ambiguity about the rationale for declaring the state of emergency, for doing it, right? And so it seemed to us that like the choice to declare a state of emergency might be one of them, where it's either, perfectly reasonable set of choices, or it's something that you're doing as part of aggrandizing power. So that was like the one manifestation that we thought we might be able to use that looked a little bit like, in the model, doing the extraordinary thing. I am 100% open to, in fact, not just open, casting nets for other things like that, right? Reforms to the electoral system that looks like it's being cleaned up, that's not it, but ones that look like you're potentially taking control over the electoral management body seems like one possibility. And the emergency declarations we can do in lots of countries. I'm not wedded to that at all. Like, I'd rather really like one place, one issue. That's fine. pretty open to a whole bunch of methods. So I don't know. To answer your question, it's like, what are the other sets? That one seems like a good one. We've gone back and forth. I mean, not back and forth. We went forth. We never went back. We just couldn't figure out, like, what are some other options besides this that would make it? And it was just, we just got stuck on emergencies, and I think we've been there. But yeah, you had a follow-up.
One additional question. In terms of the informational asymmetry, I was wondering, some of the indexes were aggregates of different indicators, and I didn't get to look into them, but do any of them include the institutional like rules or just the access to briefs or opinions, like how public they are? You know, in the US we can just go on SCOTUS blog or wherever and get the amicus briefs or what have you, but in other court systems, how is this information made public?
Yeah.
Whether that's included.
So I spent about 4 years collecting Supreme Court and Constitutional Court opinions from like 75 countries. They're at this point, certainly in all of the developed world, frankly, authoritarian or democratic, the opinions are available through the web. In developing contexts, sometimes that's true, and sometimes you'd have to, go to a place. If you run the opinion, most people are going to get information about the opinions through the media. So what we haven't done is look at, conditioning on things like how free the press are. There are, we do have data on, where you can find the opinions. Most of them, for many of the countries that we're looking at, which are the primary ones, are democratic, so that they're available. But we don't have any, I don't think, none of those indices look at the particular things you're talking about. We don't have that information.
Thank you.
I have a question about the role you're giving to civil society mobilization or civil society movements, or non-state actors in general, in terms of generating the conditions for courts to actually respond or make decisions that are protecting the fundamental regimes rules you're discussing here. I'm also thinking in terms of the recent context that has been generated with the corruption scandals in Latin America with Bulwarks, a construction company. So how courts have behaved, do you think that might be because of the pressure from civil society and non-state actors or the press in general? Or is it because the courts themselves are structured and have the right people that are trying to protect the rules on their own? I'm trying to think more in terms of, in Latin America, we know that the courts are not separated from politics.
Yeah.
They're pretty much connected and more or less captured. So we tend to see them as not behaving on behalf of democracy. So is it that sometimes, yes. So there are cases, but at the lower levels that we're seeing that the courts are responding. But,
Yeah. This issue of the different levels, I think, is really important. And again, it just comes down to, like, what was the phrase you used? Not acting on behalf of democracy? That's not quite right. But right, just like sort of acting anti-democratically. And so then it depends again on like what the concept of democracy that you have in mind for me to rationalize that.
Basically protecting the rights of
Yeah,
the population.
rights provision in all of Latin America is dominated by lower courts through the amparo process or the equivalent, the tutela in Colombia, for example, right? But so that's, if you're thinking about democracy is also including these commitments to rights, I think that's true. I guess I would say, like, maybe outside of like Scandinavia, I don't see places where courts aren't connected to politics. The Scandinavians are convincing me that may be true. I don't know how they keep doing that. They're very weird, but apparently it seems. Anyway, yeah, the way we think about it is that there are. I guess you would see it and you've read it. So the way we're thinking about it conceptually is the civil society mobilization, whether it's a variety of groups on issues or lawyers. In many cases, it's the bar mobilizing. They're the primary force, right? That is making it possible to leverage public perceptions that states should obey rules. So that's their function for us. Is they're kind of like they're providing this. They're putting pressure on states governments. That's the function that we have in mind. Not directly affecting preferences of judges. That's how we've set it up. But I think that is absolutely an alternative way to think about it. Right? So partly what's going on is they're making arguments. Some of these arguments are made in briefs, and some of it are made in conferences. We're thinking if we're setting ourselves up in a rights context, I mean that's a very important way in which civil society influences the outcome of legal conflicts is through argumentation about how to think about the Constitution. We're not really thinking about that. We're not writing about it, though it seems it's a good point. Yeah.
Instead of, can you elaborate a little bit more on maybe like the role of international courts in all this, whether what regime stability, information, kind of the flow of information? Do you think?
Can you say more on that while I think?
Well, do you think a lot of the same things that you discuss here? Do you think they apply to the international courts? Do those courts serve the same role, or because they are international? I don't know. Are they hindered that way, or are they helped?
I've been thinking a lot. So I have a paper that is about the choices that the Inter-American Court of Human Rights makes about how they ask states to remedy violations of the American Convention. So this is based in work that I originally did with George Vanberg, which is about why courts are sometimes vague about what they want. And there is incredible variation in the Inter-American Court decisions with respect to the way in which they ask states to implement certain kinds of reparations. They are always, I think I'm getting to your question, just, if I don't answer, let me know. They are always, not always, they are almost always extremely clear about monetary damages. It's not that hard. There's no informational challenge in telling someone how to deliver money from one account to another. You just have to name the currency and the amount. So they're pretty clear about that. But on a whole bunch of other issues where it may not be exactly clear how to rectify the situation. So you have a claim that the security sector has murdered 37 prisoners in Caracas extrajudicially. Who do you choose to investigate? Right? Which units do you assign to that problem? You really need to know, because they're potentially responsible for it, right? So they're really vague about that kind of thing. But the court continues to follow these behaviors up, and often over time will become more and more clear about what they want. Sometimes they'll start out by saying investigate the crime, and 6 years later they're naming particular units and telling who they should talk to and that kind of thing. That does serve potentially this kind of function that we're talking about, which is it's going to create a choice for governments to follow what this international court is asking for or to defy them. And the answer often is that this is national security interest and the court is overstepping, which is the thing you would do if in our world if you really believed this was something you needed to do to keep control of your power. In principle, it could serve this function. I'm not sure that it's doing that, right? I think the Inter-American Court has been reminding states of their obligations to international order for decades, but I'm not sure that particular court is necessarily affecting the democratic stability of the democracies it's hearing. But it is affecting the information that gets revealed about government preferences. That's true. But I'm not sure that it, in part, I think one of the reasons is I think it's a different matter to defy the Constitutional Court of Colombia is different than to defy the Inter-American Court. Just as a domestic political issue, right? A court that's far away,
Right.
packed with people from all these different countries versus your own constitutional court. So I think it's the kind of court where the backlash to a defiance might not be that high, and if it's not high enough, then it's not going to serve this information function.
Yeah, also, thank you. I mean, this is a very interesting project. I mean, it's not really my forte, but so I apologize if I ask kind of some of the questions. But to me, one thing that was kind of confusing is just so it's about democracy and democratic survival, but you have a lot of autocracy here, right? And so one of the kind of questions is it supposed to be comparing between those two cases, or you try to see variation within democracies? Because that would affect, I mean, there's theoretical issues, right, of kind of like, if you are dealing with courts, judicial independence within at least quasi-democratic regime, there's a very different understanding than in autocracies, right? And when you talk about something like political competition, so again, from a theoretical kind of, it's a bit strange to have those autocracies, and empirically you affecting your identification, but also you kind of just piling up a bunch of zero cases in your sample, so that explains some of the results in the table. That you basically just have a bunch of cases with no variation. I'm saying, oh yeah, obviously I won't expect to see anything in autocracies, and I'm not surprised to see in, say, table 1 facts, because you have all those zero cases, so obviously the ones become a bit more. So I was wondering, kind of from a theoretical perspective, is it really kind of a story of democracies? And if so, there's, one of the keys maybe to define it or kind of use some of those issues a bit more, is comparison, because you can see a lot by looking on outside of democracies to see how you can become a bulwark or democracy, what are some of the hindrances.
Yeah, that's a great question. Part of it is like sort of, this question's coming out of like what I exposed you to and what I hid.
Well, I mean, yeah, it's
No, it's a great question.
30 pages.
So right. There's an entire. This all started with a focus on democracy. So actually, I will say, there is one kernel of the idea that came out of the Chilean experience. So if you read Robert Barros's book, like he's got this great set of stories about like how the different branches of the military resolved their informational asymmetries, and how the Supreme Court, in fact, like was helping. So I was sort of drawn to that story, and then talking to all of my scholars of authoritarian court systems, they're like, yeah, that's Chile, and like literally ignore that. Please don't talk about this anymore. So most of the empirical research in the book is set in the context of democratic states. Why you saw what you saw was for a very particular reason. So the idea of the political competition story is it would hold in an autocracy as much as a democracy. In fact, it would hold, the key thing is across the regime type. So the idea, right, is once you have threats of turnover, what you want, this is not my argument, this is the literature, what you want is some form of insurance to protect you when you're out of power. And you need some kind of amount of competition to generate the incentives to create such, say, courts and respect their decisions. And so one idea that we had was to ask whether, so if you look at democracies, the judicial independence score is very high, autocracies is low. So what's going on with the competition story? Is it really just when you transition to democracy, you get almost immediately sufficient conditions to set up this court system. But conditional on being democratic, any additional amount of competition won't do much, right? And so what you're seeing in that analysis was us trying to wrestle with that, because there are country studies which will show you increasing competition gets you more judicial independence. Increasing competition gets you less judicial independence, right? And so we had an idea about whether or not that might be just because of just which set of countries they were selecting from. So that was the idea was to look at whether this was just a regime story that was driving independence, or is there something special going on in democracies? I was sort of surprised to find any effects in the democratic states. That's kind of surprised me.
Yeah, I mean, exactly, and that goes back to the kind of, I mean, because it sounds like what you're saying is there's this switch, it's really about the switch. The switch is kind of the crucial mechanism here, rather than necessarily the survival, right? And I think that's why I was kind of, but finding those effective democracies does, because you incorporate some of those anocracies, some of those, what Svoli calls consolidated, which probably won't show much effects. But then some of the kind of more recent ones, more volatile democracies, which maybe that's what explains it. And again, that add a bit of that, because then you're talking about democratic survival. There's kind of short-term survival, and there is a long-term survival. And I think that actually is kind of a cool story.
Yeah. No, thank you. It's good.
Can I just jump on? Do you think it's so for the new democracy, some confounding factor that you can have is essentially that the whole court system came from the authoritarian regime. They will be challenging new democratic things more often just because of that. Until you change all those things, which takes, I would say, one generation.
What are the consequences of that? Just that you'll see them
looking
very independent at the very beginning.
Exactly.
Because they're dealing with old things.
Yeah.
Yeah.
So essentially, so you have two players with essentially veto power at the beginning of any democracy: the military and the courts.
Yeah.
So maybe you need to exclude those initial periods in new democracy should be excluded.
Yeah, it's certainly possible. I'm just trying to think through. I'm trying to think through how what is the connection between oil resources and these things, right? Because I mean, this is like an IV analysis, so I'm trying to think through how that particular concern is not addressed by instrumenting for competition. Definitely, I mean, the simple suggestion you made I'll do, which is drop some of these early periods.
Yeah, I think I like that.
Yeah, it's a good idea.
I mean, or if there's enough of them, test them separately.
By the way, with violations of human rights, that's part of the key thing of the transition, no?
Yeah.
Because you can commit that you're not going to prosecute people that committed violation of human rights in the autocracy, because the same elites keep controls of the courts.
Yeah. Well, that's the thing. I mean, all these judges are presented with opportunities to rectify human rights violations in the period immediately following the transition. But the judges that may be making those decisions may be the same judges that were operating during the autocracy. So it's not clear that this goes back to your question about their incentives. I mean, this is the kind of thing that gonna get really mixed up and obscured in a cross-national kind of framework,
Yeah.
right?
Yeah.
You almost
They're very idiosyncratic.
yeah, exactly. Yeah, because I mean, just think about the Chile case. That the Chilean case, that the issue is there were all these opportunities, and they did nothing for a decade until like the lower court judges started taking actions, right?
The key piece of the transition, essentially.
Yeah, I mean, that's the
keeps
thing.
control of the central bank,
Yeah.
the military,
Sure.
and the courts are
Yeah.
part of the legislature. So
Right.
Pinochet was part of the Congress for many years.
Yeah, it's just that if that were true, then that court would not look like it started acting independently relative to what it was doing before. Which I guess is, well, it depends who you, I mean,
Yeah,
It depends. It could be the bulwark of democracy,
yeah.
and that's
Sense
the
you
linchpin.
said, kind of holding to-
Yeah.
Why not jump in just real quick?
Yeah, so
Thank you very much for
I'm
your
sorry,
presentation and sharing your paper. Super interesting. I just want to piggyback on what someone said about the legacy of the dictatorships of
Yeah.
past. I think there is a lot to gain from Albertus and Mainaldo, 2018, that have looked systematically at different types of democracies. So some democracies, they inherit a constitution that was designed and implemented by the previous dictatorship. And these democracies, they are rigged in favor of not just any given minority, but a particular minority, the authoritarian ruling coalition that exited democracy on favorable terms. That might include the military, some powerful business organizations, and Chile is a clear example. And then you have these democracies that got rid of that old, the constitution of the old authoritarian guard, and they have a more majoritarian institutional architecture with less executive constraints and perhaps a more centralized, as opposed to federal political system, and a less powerful Supreme Court. So I think empirically, I think you can look at this more systematically as opposed to just say, well, this is Chile, this is idiosyncratic. It's actually quite a considerable proportion of democracies that are ruled by these outgoing authoritarian, the constitution of outgoing elites. And I think a second, and related to that, I think there's a lot to gain from treating democracies as two political systems that can be ruled by a particular ruling coalition. Right? Democracies have ruling coalitions as well. The forces that pressured elites